We've titled this the Foundations Panel, and we're grateful to Carswell for sponsoring today's panel. There are 4 papers which will be presented through the panel, after which we will have our question and answer period. Our first presenter will be Professor John McLaren from the University of Victoria. His paper is entitled Searching for the Soul of Canadian Common Law Education, an Historiographic Update. Second presentation is by Thomas Morrow, Assistant Professor of Legal Studies at the University of Ontario Institute of Technology. His paper is jointly authored with Roderick MacDonald, Professor of Constitutional and Public Law at McGill University, and it's titled Decolonizing the Law School. The third presenter is David Sandomierski, a PhD student at the University of Toronto Faculty of Law. His paper is entitled Educating Lawyers, Educating Citizens, and Re-enchanting the Legal Profession. And rounding out the panel are Rosalie Jukier and Kate Glover. Rosalie is an Associate Professor and Associate Dean Graduate Studies at the Faculty of Law, McGill University. And Kate is a doctoral candidate of civil law at McGill University Faculty of Law and a Vanier Canadian Graduate Scholar. Their paper is entitled Forgotten, the Role of Graduate Legal Education in the Future of the Law Faculty. Each of our presentations is going to be a strict 20 minutes, followed by question and answer. So, Professor McLaren.
Thank you very much, Barbara. I'm going to try and do 3 things in this presentation. First of all, you can't hear me.
I'm just wondering if your microphone is on there?
Is my microphone on? It is? A little bit closer. Is that better?
Yes.
John? Yes. I'm going to try and do 3 things. The core of what I'm going to say is about the past of law school. I'm going to say a little about the present of law school, and I'm going to give you a one-liner on the future of law school. And for those of you who are not historians, you may want to turn down your hearing aids at this point or turn up your iPods. So, in 1985, I observed that accounts of the development of legal education in this country have been limited in scope and anecdotal in character, with no attempt to engage in analysis, let alone in intellectual critique of earlier systems of training lawyers. In 2013, happily, we have a clearer picture of the professional and academic cultures that have inspired and conditioned legal education, the relationship between those cultures, and some insight into what was being taught and how. In short, the learning experiences of law students. The evidence is found in recent histories of particular faculties, of groups of law schools, in intellectual histories of legal thought, and in biographies of judges and lawyers. The work of Wes Pugh, in particular, has been of central importance to the project of opening up the legal histories of both the profession and the academy. Wes has weaned us off the idea that the history of legal education in Canada is invariably reducible to a Manichaean struggle between angels and demons. His exploration of legal education in the prairies in the first 3 decades of the 20th century demonstrate clearly that by the end of World War I, the common purpose of elite practitioners and the leading law professors was to use legal education to produce professionals committed to the following: British values and notions of justice, social stability, Christian morality, gentlemanly behavior, individual effort, certainty in the law, and minimalist state interference in the economy. Pugh has also demonstrated by research into syllabuses, teaching materials, and pedagogy the adoption and adaptation in Canada of the teaching learning practices of the leading American law schools, most particularly Harvard. By the early 1930s, other visions of law and governance and their educational significance were beginning to vie with the suppositions of the Canadian Bar Association and its educational intimates. Dick Risk's inspired intellectual legal history and the engaging biographical scholarship of Philip Gerard provide the evidence. If Sir James Aikins and Professor Ira McKay believed that the die was cast for a legal education system that emphasized exclusively the power of tradition, judge-crafted law, and minimalist government, the vagaries of the capitalist economy and the social disruption of the interwar years were to subvert any comfortable thoughts along those lines. As John Willis later explained, for legal educators, it was a time when the world was turned upside down. At the center of educational innovation was W.P.M. Kennedy's idiosyncratic University of Toronto Law School, committed to investigating and teaching law as a humanist and social science discipline. There were also the spirited efforts of individual scholars in several professional law schools. Frank Scott at McGill, John Willis and Vincent MacDonald at Dalhousie, and J.A. Corrie at Saskatchewan. These men sought through their teaching and writing to elevate law as an instrument of government dedicated to constructing a more equitable nation, to focus on the new administrative processes designed to implement proactive social and economic objectives, to question seriously the formalistic approach of the courts to legislative interpretation, and to redress the power imbalance in the Canadian constitutional order wrought by the Judicial Committee of the Privy Council. It was through their efforts that administrative law began to feature in some law schools, that legislation and progressive legislative interpretation secured a firmer place in curriculums, and that the realpolitik became more central to discussion in constitutional law classes. The social convulsions of the 1930s and elite anxieties about the spread of left-wing credos among the working classes, evident in repressive laws, secret policing on a grand scale, and aggressive law enforcement, and moves to greater industrial organization by workers in the face of employer resistance, also had their resonances in several of the country's law schools. Frank Scott at McGill, openly a member of the CCF, was to be a tireless champion of civil liberties in his own province and Canada more generally, and representative of a new breed of legal academic who combined teaching and public political advocacy. In the nascent field of labor law, Jacob Finkelman and Bora Laskin of the University of Toronto brought their experience, born of working with unions, into the classroom. Both there and in public, they argued the case for fair collective bargaining as the preferred strategy for resolving industrial disputes and against the restrictive and employer-loaded doctrines of the common law. After 1945, Frank Scott, with vigor and openly, and Bora Laskin more subtly and doctrinally, were to press the case of a readjustment of the division of powers in the Canadian Constitution in favor of the federal parliament and government, a position now challenged by advocates of cooperative federalism. Dick Risk notes that with the exception of Scott, the debate over the Constitution in Canadian law schools after World War II took place largely within doctrinal boundaries. This may be the result, he suggests, of a sentiment for the need of a, quote, faith in shared values and a peaceful society, close quote, and a belief, open quote, that the job of lawyers and law teachers was to implement these values, close quote, allied with, quote, a belief that the job of lawyers and law teachers was to implement these values. This, he suggests, was allied with a pervasive need to establish the post-war law schools as professional schools. These goals, he says, may have tempted law teachers to demonstrate their usefulness to the professional enterprise and to shy away from debates about values, especially their own, as their own were likely to be to the left of the practicing profession and their clients. An interesting comment, I think. If that is so, then during the 2 decades after World War II, Canadian legal education, with the notable exception of Ontario, was marked by a return, if not to an alliance between the academy and the profession, to at least a respectful degree of informal accommodation. There were, however, areas where sentiment in the academy, leery of the claim of the values of the British Constitution at work in this country and the efficacy of judge-made laws in protecting the less privileged in society, was clearly in advance of both the profession and the judiciary. Beyond labour law, both Scott and Laskin, as well as Maxwell Cohen, worked to improve Canada's mechanisms for protecting civil liberties and human rights, and to deal resolutely with a patent weakness of traditional law in the face of such acts of state as the Japanese-Canadian internments of World War II. The fact that the professoriate now included some who were either committed political activists or from ethnic and religious minorities meant that not only were alternative voices heard in the academy, there were also some opportunities for students of liberal progressive and even leftist persuasion and from minorities to find connection with and inspiration among the faculty. Now, in the ostensibly buttoned-up world of Canadian legal education before 1970, there are examples, some of which I explore in the longer version of the paper, of graduates who, despite compulsory curriculums and a dominant lingering vision of the profession as the preserve of right-thinking Anglo-Saxon gentlemen, were very much their own people, culturally, politically, and in terms of gender. These individuals, with support from their communities, from friends and families, and even sympathetic professors, were able at law school to craft a career path for themselves in the profession that accorded with their rather different humanistic view of the world and their moral and cultural values, and who were not afraid to test the potential of the law for achieving greater justice through law. The point of this excursion is to suggest that there is one element of the story of the history of legal education that is too readily regarded, the attitudes of students to the teaching-learning process, especially those with distinctive intellectual and vocational objectives. By the mid-1960s, the balance between traditional and progressive elements in the process of Canadian legal education had shifted somewhat further in favor of the latter, as faculties expanded and became more diverse in age, educational experience, and cultural background. Both teaching and scholarship, however, was still largely doctrinal in character, as new legal academics felt their way and dealt with a deficit of published texts in Canadian law, which I can tell you, as one who started teaching in 1964, was a problem. One major element of the Canadian population still absent from the world of legal education and so the profession of law was women. The first full-time female faculty member was appointed to a Canadian law school, I think Manitoba, in the mid-1960s. The culture of law schools was still predominantly male and so not welcoming to women. The struggle of Canadian women for recognition in both the academy and the profession was another fertile field for legal historical scholarship, and that's grown since 1985. Led by the inspired research of Constance Backhouse, Mary Jane Mossman, and Joan Brockman, we now have a very clear idea of the barriers that existed to women qualifying for and joining the profession, the patriarchy that afflicted both law schools and the practice of law, and the courage of that little band of women who opted for law schools, graduated, sought to make legal careers for themselves, and battled with the notion that this was a profession that required masculine strength and intellect. Together with feminist legal studies more generally, this scholarship has, I would suggest, quote, turned the world upside down again, close quote, in legal education, through its critiques of law and its gender biases, in encouraging women legal scholars and students to engage with the law critically and to bring their own experience and wisdom to reform or even revolutionize legal thinking and action. Feminist legal theory has also provided points of contact with older radical traditions of scholarly critiques of law. It has interacted too with the law and society movement, with its roots in the realists, the work of the realists in the US, which steadily grew in influence in Canada from the mid-1970s, as more scholars were introduced to this scholarship and its potential. All of these undercurrents, identified in and encouraged by the Arthur's Report in the early 1980s, acted as spurs to new forms of critical legal scholarship and teaching. All law schools include scholars committed to challenging discrimination within and outside the law and its institutions, and using their diverse experience of life to imagine and press for more accommodating and inclusive legal orders. A newer and equally significant milestone to these developments has been the emergence of Aboriginal law. effectively effaced from public and legal and professional consciousness by the legislative banning of First Nations retaining lawyers to assist in furthering their claims in 1927, scholarly concern and teaching in this area emerged in the 1970s when the ban had been lifted and litigation on Indigenous claims started up again in this country. A small number of non-Aboriginal faculty members began researching and teaching the contours of Canadian law as it applied to Aboriginal peoples. Through the initiative of Roger Carter, then Dean of Law at Saskatchewan, and his colleagues, the Native Law Centre was established to further research on First Nations legal issues, as well as encouraging and assisting Aboriginal individuals to attend and to succeed in law school. The results of these initiatives are evident in the addition of courses in Aboriginal law and the steady increase of First Nations law graduates working in the profession, in Indigenous government, and in the academy. The presence of Aboriginal faculty in several law schools, we think of John Burroughs, for instance, and James Youngblood Henderson, has presented the opportunity for students to reflect on the sad history of the treatment of Canada's First Peoples and of the attempts to use law to erase their cultures and languages, and at the same time to seek to recover First Nations law as one important step in taking control of their own destinies. Indeed, we may be on the cusp of the founding of the country's first Indigenous law degree program at the University of Victoria. And if you think that can be done in 2 years, dream again. For 55, now we get to the present. For 55 years now, academic legal education has been the only avenue of preparation for legal practice across this country. Most law students possess a degree in another discipline. Many have engaged in life-affecting experiences before law school, in the workplace, in business, in government, in NGOs, or community and charitable organizations. Students are older than their counterparts of yesteryear. Ethnic and cultural groups now constitute a larger segment of law school classes and often bring their particular life experience to bear on both law school cultures and on the law and justice system. This has widened the nature of debate and expanded the number of voices contributing to the dialogue. After first year, there is a far wider range of optional courses that was true under l'Ancien Régime, reflecting both the increasing complexities of law and the realities of and research on expanded legal engagement with political, social, economic, cultural, and ecological issues. This scholarship feeds into the learning experience of students, creative solutions to new legal problems, critiques of law and justice systems, proposals for law reform, and yes, unabashed intellectual reflection. Law professors work comfortably and creatively both with practitioners and with a wide range of social actors and those with expertise in other disciplines. Many are imaginative pedagogues who understand much better than my generation the cognitive space that today's students operate in and how to engage and inspire these people. Not a few engage in pro bono advocacy, protecting and furthering the cause of democracy, collective and individual rights, environmental values, and intercultural relations here and internationally. They stand as impressive exemplars and mentors to students of what it means to work with legal knowledge in an increasingly complex and pluralist legal order. Some work in sophisticated and reflective clinical programs and practicums, encouraging their students to engage in advocacy roles on a wide range of social, economic, and cultural issues. As a result, law is a more broadly contextualized, connected, and intellectually challenging discipline than it used to be. Why, I hear you cry, is this so? My almost last hurrah. Dick Risk provides an answer in his perceptive working of Dorothy's Trip to Oz, in which he describes her discomfort comparing constitutional law conferences in 1960s Kansas and in 2000 Oz, or the University of Toronto. While there were elements of discourse analysis and doctrinal discussion in 2000 that she, a constitutional scholar of the 60s, would have recognized, there was much that was strange. A conceptual and theoretical focus on both individual and collective rights, a greater concern with political context and the implications of decisions, an enthusiasm for broad comparative study of other constitutional systems, far transcending the US and the UK, a greater attraction to investigating law's relationship to issues such as citizenship, globalization, and the environment, and a clear commitment, I love this, to understanding the historical record. Faculty members, she would have observed, had a greater range of interests and knowledge and a wider selection of literature on themselves. And what is risk's explanation? That the earlier scholars thought of themselves as lawyers, teaching students to become lawyers. Contemporary scholars, in contrast, tend to think of themselves instead or as well as members of a university, studying and teaching law as a social, historical, and theoretical enterprise. With differences in degree, content, and context, Dorothy could be describing the temporal gulfs between legal educators in research and teaching in any number of areas of law in 2013. The question for the future: can we or should we turn the clock back and return Dorothy to Kansas? I think not. And I want to end with a wonderful quotation. It's from the year 1957, and it was when the deal between the Law Society of Upper Canada and the province's universities to have academic law schools was being brokered. And part of the role of negotiating that, an important part, was that of J.A. Corrie, who I mentioned earlier on, who was by this time vice principal of Queen's University and an eminent political scientist. And here is his quote, which you should type out, I think, and keep under your pillows at night. The whole point of housing law schools inside universities is that law teachers should be an integral part of the university community. The outlook on law is broadened, its larger social significance kept more closely in mind by law teachers associating closely with teachers of the humanities and social sciences. If law is to continue as a genuinely learned profession in the circumstances of the 20th, read 21st century, when everything is being seen to be related to everything else, law schools should be closely integrated with universities. I rest my case.